This is Michael Popok, Legal AF After Dark. Presidential immunity. What is immunity? Does Donald Trump have it? Does he have it for civil cases brought against him? Does he have it for criminal prosecutions brought against him? What's all the commotion about immunity, and why are appellate courts getting into the mix, including the U.S. Supreme Court? This is one of our major topics in our most recent episode of the Legal AF podcast, only on the MeidasTouch network. So here's a little teaser. Listen to Ben Meiselas. Listen to me. We break it all down. It's coming up right here.
The problem that special counsel Jack Smith confronts, among others, is that he can't say in his brief that the reason that this needs to be expedited is that we will not have a democracy if Donald Trump is not tried in 2024. And that's one of the main reasons why this case needs to be tried right away. He can't say that in the brief, that one of the two political candidates supports the destruction of the judicial system, and that this case needs to be tried not right at the end of the election cycle, because Jack Smith is trying to pursue this as even-keeled, as we're not treating him differently than everybody else. But at some point, as you get closer to a November election, you're not going to have a trial in October. I mean, I don't think, are you going to really have a trial, starting late September, where literally a jury verdict can be the same day as the election? And so you fundamentally can't express the threat here, so it goes unstated in all of the briefs that if Trump were, and by the way, I'm very confident that President Biden is going to win, and I don't want to be overconfident and let my overconfidence in any way shadow the urgency of everybody needing to get out there to vote and to register to vote and do all of those things. But Jack Smith can't talk about some of the realities that are being confronted right now. So I just want to say that, piece from the outset that just is a reality. Number two, I think that when it comes to Judge Tanya Chutkan, I've applauded the work that she's done over and over again, but I want to be critical of one thing that I think she was a little bit too safe on. And now we're seeing actually the 11th Circuit come out different when Jeff Clark made the same argument that Trump made before Judge Tanya Chutkan. Judge Tanya Chutkan issued a stay of the proceedings before her in the district court proceedings. So all of those proceedings are stayed. And by the way, I don't think anything can happen with juries or jury questionnaires or even though the initial jury forms were sent out, nothing can happen in that case substantively or procedurally, nothing. It's shut down in the district court. And one of the things that Judge Chutkan relied on is the Coinbase case. And the Coinbase case was a case decided by the Supreme Court in June of 2023 that said that district court proceedings in that case should be totally stayed pending the appeal process. And that's one of the things Donald Trump cited. Look, I'm making an absolute presidential immunity claim. My motion to dismiss was denied. Look at what Coinbase said. But the Coinbase decision related to a district court's denial on the issue of a motion to compel arbitration and arbitrability. And Popok, you may recall when I was analyzing the Coinbase decision in Donald Trump's brief before Judge Tanya Chutkan ruled, one of the things that I was saying is that Coinbase just relates to arbitrability. It doesn't relate to absolute presidential immunity. And where the D.C. Circuit Court of Appeals in another case, Blasingame, a civil case, not a criminal case, in a civil case, had already determined that Trump doesn't have absolute presidential immunity regarding his conduct for January 6th because it involved campaigning and election activity. Whereas arbitrability is this well-established doctrine, arbitration clauses. In the D.C. Circuit Court of Appeals, we know that Donald Trump, in a civil case, does not have absolute presidential immunity based on Blasingame. So he clearly would be outside the outer perimeter of absolute presidential immunity when it comes to a criminal case. So this isn't a well-established doctrine that Donald Trump could be entitled to this the way a party could be entitled to arbitrability. So that's why I was surprised that Judge Chutkan, relying on Coinbase, among others, and Blasingame, actually stayed all proceedings, because one of the things that the 11th Circuit said in denying the motion for stay by Jeff Clark, when Jeff Clark cited Coinbase, was no,
wrong.
Coinbase relates to arbitration. Coinbase has nothing to do with your claim of federal officer removal, and just kind of moved on. But Chutkan bought into the Coinbase logic. I think that honestly, some of Trump's constant barrage of filings, and if I'm being totally objective here, kind of psyched her out a little bit on that one to go the overly safe route.
I was surprised. I agree with you. I was surprised she stayed the whole proceedings, and I think there's some things she can do on the periphery. But I agree with you that everything else is certainly stayed. And I think she went too far. And I think Coinbase is not helpful in the analysis. And as you said, the 11th Circuit panel that just came out. And now what we're watching, as I said at the start of the podcast, is we're watching now not just the Supreme Court ruling, but we're seeing D.C. courts of appeal and 11th Circuit courts of appeal struggling with how to apply in real time, including citing cases that they may have just ruled on 2 days before, trying to map that onto the conduct of Donald Trump or the arguments of Donald Trump. And we're watching that messy struggle right now, some of which will get resolved ultimately by the U.S. Supreme Court. But you're totally right. I don't think Coinbase and that case about arbitration is relevant or applicable to or precedent at all. And I'm surprised that she actually took that particular bait, so to speak. My only other point before we talk about our other things on the podcast today is that one of the reasons, and there's speculation among Supreme Court watchers, that one of the reasons the U.S. Supreme Court did not take up the direct appeal on this, what we keep referring to as the writ of cert, C-E-R-T, is because they didn't like the fact that it was going to be the special counsel's office arguing on behalf of the government, the United States, at the Supreme Court level, rather than what they want to see and what they're used to is having the issues framed in the way, in the vernacular, in the foreign language of the Supreme Court, the way they like it, by the office of the Solicitor General, who is the head lawyer, in the executive branch that argues on behalf of the Department of Justice. Yes, Jack Smith was smart and went out and got and put on his team a Supreme Court expert in the form of a former deputy solicitor general to sign the brief and would have made the argument. But now, once it comes up to the D.C. Court of Appeals, it will be Jack Smith's team will be on the brief, but the argument will likely be made and framed in a way that makes the stodgy, Byzantine world of the, old white guys, I'll just call it what it is, on the Supreme Court happy. And that's going to be through the Solicitor General's office. And so we're going to also see a little bit, not to get too much inside baseball, but the Supremes were like, no, we want the Solicitor General's office to do this. And the Solicitor General's office was kind of consulted, but they were not on the brief that was filed by Jack Smith. And that, I think, goes to one of the reasons why they want to see it come up in a more traditional way, maybe a fast track way, but a more traditional way. But you're right. I never liked the fact that, and it always kind of made my nose scrunch up that Chutkan so quickly, and we liked everything that she's done so far, said, yeah, I'm going to stay on this whole thing. Now, at the end, she'll be completely exonerated if her really amazing analysis, which we always have credited, is then supported or even complemented by what the 3-judge District Court of Appeals, probably written by Judge Pan, is going to do in the next 2 weeks, which then gives the Supreme Court, who of course can ignore everything, but gives the Supreme Court a really good record and a really good set of analysis to work off of, rather than what I feared. That's why, just to square the circle here and round it out here, I was a little troubled by the balls out approach of Jack Smith to say, you know what, Trump, I'm going to call your bluff. I'm going to go right to the Supremes. You want to keep arguing presidential immunity for everything criminal? Great. Let's go right to the Supremes right now. And there was a little bit of bluff, a little bit of call your bluff game of chicken going on there. Except if you lose the game of chicken, then you just got the mischief that could be created by a very right-wing 6-3 majority where Roberts doesn't have control. And you get a crazy ruling the way they did, which I thought was unfair and not jurisprudentially sound in Bush versus Gore and a new president being picked, because they don't have, at least we keep them honest by having briefing and oral argument and a record from Judge Chutkan to the DC Court of Appeals. It's a little bit harder for them to kind of throw over the game board. If they're just said, okay, you want us to decide on our own, let's go. I was slightly troubled by that. And I'm actually, my temperature has dropped a bit since it's going to go this normal, hopefully more expedited route to get to them. Well, if you like lawyers who know what they're talking about at the intersection of law, politics, and justice, you've come to the right place. Legal AF on the MeidasTouch network. Help get them to 2 million free subscribers. Free subscribe. They're so close to reaching that threshold. And then, if you know what I'm talking about here, about things related to Legal AF at that valuable real estate corner, then we welcome you. Thanks for being with us along for the ride. If you have no idea what I'm talking about, I'm Michael Popok. That was Legal AF. And you can join us every Wednesday and Saturday at 8 p.m. Eastern Time. I co-anchor it on Wednesdays with Karen Friedman Knifilo, on Saturdays with Ben Meiselas. And then you can pick it up on audio podcast platforms of your choice. And then the leaders of Legal AF do hot takes like this one about every day, about every hour, right here, MeidasTouch Network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.